Hello everybody, my name is Metta. Tjia. Here I will explain about Privat International Law. What is Privat International Law? Anybody know? Here are two experts who argue about the meaning of Privat International Law. The first one, according to Professor Dr. Mokhtar Kusuma Atmaza, Privat International Law is the whole law and principle that regulated civil relations across national border, or in other words, laws that regulate the relationship between legal actors, each subject to different civil or national law. The second one, according to Van Brakel, Privat International Law is a national law specifically reserved for international matters. So, Privat International Law is the whole legal principle and principle that regulate civil relations that across national border, or laws that regulate civil laws relationship between legal actors who are each subject to different civil or national law. Next, we will discuss about the history of Privat International Law. The history of Privat International Law itself is divided into 5 stages. The 5 stages will be briefly described as follows. Stage 1. This stage is the stage during the Roman Empire in 2 to 6th century AD. This stage is the beginning of the historical development of Privat International Law. It begins with the relationship between the inhabitants of the province or municipality and the Roman citizen. The law used in EU Civil, which is a law that applies to residents or Roman citizens who have been adjusted to the interests of outsider or international relations. There are 3 important principles in Privat International Law, which consists of the lex recitae principle or lex cite, the lex domicile principle, the lex loci contractus principle. Stage 2, the second stage of the history of Privat International Law, is a period of the growth of the personal principle of Privat International Law in the 6th to 10th century. At this time, ius civil was useless because during the Roman Empire was conquered by barbarians from Europe, and the former Roman colony was occupied by different peoples. The position of ius civil is not so important because they have enacted personal law, private law, family law, and religious law, respectively. This has changed the territorial principle into a personal principle. There are 4 principles of Privat International Law at this time, which consist of principles that stipulate the law that applies to a case is the personal law of the defendant. The principle that carrying out one's law must be determined by personal law. The principle which state that the issue of inheritance must be regulated in the personal law of the defendant here, and the principle of legalization of marriage is carried out by the husband personal law. The stage 3, or the third stage, represent the growth of the territorial principle of the 11th to 12th century in Italy. In this history of Privat International Law, the growth of the genealogical principle is difficult to sustain. This is due to the result of the structure of society that tends toward territorial society. The growth of private international law is what is often referred to as the statute theory in the 13th to 15th centuries. Stage 4. This fourth stage is the development of the statute theory. Statute theory developed in several countries such as statute theory in Italy in 13th to 15th centuries, statute theory in 16th century France, and statute theory in the Netherlands. Stage 5. In the fifth stage, this is the history of private international law and universal law in the 19th century. One of the figures who sparked this theory is Friedrich Karl Savigny from Germany. The five stages above are the origin of the emergence of private international law. Next, we will discuss about general rules of the private international law. Private international law exists to find out what will be the applicable law in the dispute involving a foreign element. Illustration: there are two parties of the contract of sale of wheat. One party is Indian and the other is German. They both come in contract of sale of wheat from India. Now, if any dispute arises between the parties and a case comes before a court, then the court is faced with a dilemma as to what should be the applicable law, whether the law of India or Germany. Here, India is a part of a Commonwealth countries, and Germany, on the other hand, is a member state of the European Union and follows civil law. India follows traditional private international rules, and Germany has private international law which are unified among the member states of European Union. Traditional rules of private international law. Formal validity of marriage is governed by lex loci celebrationis, that is, law of place where marriage was performed. Essential validity of marriage or capacity to marry is governed by lex domicile of party. Title of movable property is governed by lexitus at the time of transfer, mostly in the case of sale. Succession to movable property is governed by lex domicile of deceased on the date of death. Succession to immovable property is governed by lexitus, that is, a law of place where immovable property is situated. Law of procedure is governed through lex fori, that is, law of forum. In case of contract, liability is governed by applicable law or proper law of contract. Law of liability in tort is governed by lex locidality, that is law of place where damage occurred. Next, we will discuss about characterization of private international law. Characterization in conflict of law is the second stage of the procedure to resolve a lawsuit that involves foreign law. It is used to determine the correct choice of law rules based on the circumstance of the case, primarily relating to matter of property. This is to reconcile difference between law of different legal jurisdiction. The objective of characterization is to determine that the nature of the action brought by the defendant in order to determine what relevant rule of applicable law apply. This may result in applying law which differ from the lex fori. Additional factors make this determination not necessarily a simple process, as the incidental question and renvoi can make determining the initial point of reference difficult. Next, we will discuss about renvoi. In conflict of law, renvoi from the French meaning is sent back or to return unopened is subset of the choice of law rules, and it may be applied whenever a foreign court is directed to consider the law of another state. The procedure for conflict case. First, the court must first decide whether it has the jurisdiction to hear the case, which will involve addressing the question of whether the plaintiff is attempting to manipulate the judicial system by forum shopping. The second characterization, the court must analyze that case as plead and allocate each component to its appropriate legal classification, each of which will have one or more choice of law rules attached to it. Third, the court will then apply the choice of law rules in a limited number of cases, usually involving family law issue, and incidental question may arise which will complicate this process. Application of renvoi because the doctrine is considered difficult and it results at something unpredictable. Its application has generally been limited to the validity of will and intestate succession, retrospective legitimation by the marriage of the natural parents. However, there are indications in some states that it might also apply to issues in family law, namely the capacity to marry and the formal validity of marriage. Example of renvoi case that a problem inheritance of a Canadian citizen who has domicile origin in Canada, last domicile before dying were in Germany. Before he died, he didn't have time to make it well. He left behind a number of moving objects in Canada. The problem that arises is division heir to the studio passed in the Dutch court. Conflict of law rules of private international law determine that inheritance of object in motion without will be arranged based on the last domicile of the heir. Therefore, Based on the rules of the Dutch, the judge determined that the law based on the case in German law. Therefore, judge of German legal provisions. German legal provisions state that the issue of inheritance is regulated by law. Finally, judge used the law Canada to try this case. The next, we will discuss about forum shopping. Forum shopping is a colloquial term for the practice of litigants having their legal case heard in the court to most likely to provide a favorable judgment. Some jurisdictions have, for example, become known as plaintiff-friendly and so have attracted litigation even when there is little or no connection between the legal issue and the jurisdiction in which they are to be litigated. Examples of forum shopping include the extraction of foreign litigants to the United States due to its expensive acceptance of personal jurisdiction and favorable litigation claimants, and the United Kingdom for its stricter defamation law and generous divorce settlements. The terms has come adopted in a wider context for the activity of repeatedly seeking a venue of willing listener for a concern, complaint, or action until one is found. Simple case, qualification case IPB and the United States case fetch IPB made an agreement to send 800 monkeys to America. Only their children will be taken and the baboons will be returned to Indonesia. It was agreed that the economy price was 80 million and the United States only need their children and had to have children in the United States. While the plane was still in Switzerland, a monkey was stressed and released, giving birth to a cub. Because the mother had been paralyzed and died, the IPB veterinarian injected the young monkey out of pity. Lawyer from the United States sued IPB on the basis of animal protection and was deemed not to fulfill their performance perfectly and kill a monkey club. On the one hand, pests in Indonesia are no more than pests, while for the United States there are animals that must receive protection. Let's for it. Which court has the authority to try this case? Namely the Bogor Court, because it is in accordance with the principle of the actor secutor forum rei, namely that the lawsuit is submitted to the court, the place where the defendant resides. Since the IPB defendant resides in the drill, the authorized forum must be the residence of the defendant. Main link point. The main connection point are the factor and circumstance that indicate that we are dealing with private international law events, or factor and circumstance that indicate that a relationship or event is a private international law event. In the case, the mainly connecting point is the nationality of the parties, where the plaintiff is an American lawyer, while the defendant is an Indonesian citizen from an IPB veterinarian. Secondary connecting point are the factors on circumstance that determine which state law should be applied in the event of private international law. In this case, the secondary link point is because in the agreement between IPB and the United States, there is no choice of law or choice of forum which is expressly regulated in the agreement. So there is more than one secondary link point, namely lex loci contractus, the law where the agreement is executed, lex loci solutionis, the law where the agreement is executed, lex loci delicti commissi, law where illegal acts are committed. The most characteristic connection, the most prominent party in the contract. Applicable law. Based on the lex loci contractus, the applicable law is Indonesia civil law because the agreement was made in Indonesia. According to the lex loci solutionis, the applicable law is the law of the United States because the agreement is made in United States, namely the baby monkey who is promised to give birth in the United States. Based on the lex loci delicti commission, the applicable law is Swiss law because an illegal act of injecting monkey cubes was promised to be carried out when the plane has crossed Swiss territory. Based on the most characteristic connection, the applicable law is Indonesia civil law because the most prominent party is IPB in Indonesia as the monkey seller because IPB has to hand over the apples, care for the apples properly until the apples are handed over to the United States. And the sale and purchase agreement, the most prominent of or dominant party is the seller, in this case IPB. Thank you for watching.